Hello, I'm Graeme Fraser and I'm partner and head of the family law team at North London firm OGR Stock Dunton. What I'm going to talk to you today about is how we can look at minimising confrontation and conflict when it comes to child arrangements during the lockdown. And what we're finding nowadays is that there are unprecedented pressures for anyone involved with providing family law advice, parents and the family court. And I'm going to describe them to you today. But rather than throwing up our hands in horror, we really do have good opportunities now to reduce conflict when we look at negotiating child arrangements for separated families. I have to say this is one of the most difficult times I've ever felt in practice. And the reason for this is because the COVID-19 outbreak in itself created a massive increase in confusion and distress for parents. We know that many family lawyers have received lots of inquiries about where children will be living, that there have been complaints that children aren't being returned or being made available to spend time or live with their other parent. And these social distancing measures currently in place are challenging enough anyway for children because they face disruption to their education, health and care arrangements without the added burden of parental conflict. Now we know that the longer that COVID-19 goes on, the greater the trauma in the children's lives. And therefore it really behoves us to try and find ways that we can reduce conflict confrontation. Now, there have been various attempts to set guidelines in respect to the various restrictions now in place. And the most significant of those was on the 24th of March, when Sir Andrew McFarlane, the president of the Family Division, clarified that while children under 18 can be moved between their parents' homes under the government guidance issued alongside the stay-at-home rules immediately following the lockdown, this did not mean that children must be moved between homes. Where there's an agreement, parents could informally vary an order during the lockdown, although I should mention that it was announced through national media last week that Sir Andrew McFarlane does expect parents to obey child arrangements order and to carry them out wherever they can. But if there is a disagreement and one parent is concerned, then that parent may exercise their parental responsibility, which means that they can unilaterally vary the agreement to one they consider themselves to be safe. Parental responsibility, therefore, rests with the child's parents and not with the court. However, that means that the family court will only be able to look at the position retrospectively to decide whether each parent acted reasonably. Now, at the time of delivering this webinar, I should say that we are right in the middle of COVID-19, and we do expect that some of these restrictions will be eased and that the guidance that the President has given will be reviewed from time to time. But this is probably the high level of the watermark. The other thing that happened is that the courts have been closed to the public. So there was an announcement on 23rd of March by what's known as the Remote Access Family Court. That's run by another High Court Justice. And the idea was to continue substantially the full operation of the family justice system, notwithstanding the COVID-19 pandemic. As I speak, there is currently a survey in relation to how users are finding the family court, and they will be considered and the President will issue guidance very shortly again. But what has become clear following the McFarlane guidance is that the courts themselves have issued a set of listing priorities at the beginning of April, which emphasise that only priority work must be done. It's also been made clear in a letter from the top judges in the country that, generally speaking, there will be postponements unless the work is urgent. So what this means And my experience so far also is that many family court hearings are being postponed. If you want to make sure your hearing is heard in court, then make sure your specialist family legal advisors are doing the right work to make sure this is possible. But I have to say that in spite of all of this, what we need to understand is that the way of the future is going to be different with child arrangements, because these processes are being steered away from the court. And coincidentally, also at the beginning of this month, a private law working group recommended a radical system change for the benefit of future generations. And the president, again, he was calling for public education about the effects of parental conflict and professional support for families other than lawyers or judges, so that courts should be seen as the last port of call when disputes arise. So what's clear is that increasingly these cases are going to be decided away from the court, and that's the general direction of travel. Now, what that means in itself is that parents who are in dispute, and there are very many of them, very unfortunately at the moment, all these measures will not stop them being positioned or hostile. And it's been my experience that the effect of the restrictions and the guidance does create more positioning and hostility. It's something I'm really worried about. So I've thought of a few solutions to this and how we can best practice. And if we take these approaches, I do believe that this can reduce adult conflict, and we can improve upon the pressures that have been created by the lockdown and what will happen when the COVID-19 issue comes to an end. The first thing to bear in mind is that CAFCASS issued guidance on the 20th of March, and that provides some very helpful tips for co-parenting, not just during COVID-19, but beyond. These include things such as maintaining a sense of routine for children, which includes ensuring their meals at meal and bedtimes are kept in routine. Also maintaining the routine of spending time with each parent. Everybody likes routine, but no more so than children. And ensuring that complying with a child arrangements order should be the norm, unless children or others are placed at risk. And the risk they're referring to here is the risk of contracting the virus and the impediment to public health. And also communicating clearly and honestly with the other parent if one parent is unable to maintain the child's routine. This is basic co-parenting, and it's very, very helpful. But in this particular situation, we are looking at situations of illness, self-isolation, or where people may generally not be available for various reasons to ordinarily support the child's contact. So I would certainly endorse that CAFCASS approach, and I think it was a very good piece of work. Second thing to bear in mind is that we do have at our disposal a large range of dispute resolution or problem-solving processes in family law, which enables parents to really assist them where they can't negotiate without help, where they do need the assistance of another professional. Now, we do have very established processes, including mediation, collaborative law, and arbitration. And I would say that all of those generally work better than going to court, as there is likely to be either a smoother way of operating these matters, or there is likely to be an outcome that both parents consider fair and is more practicable and workable for the children concerned. But there are also newer methods coming to the fore, such as parenting coordination. And I would certainly endorse using a therapeutic approach, which likely means using a family therapist or what's called a family consultant, as a means of resolving child arrangements disputes. This means involving a therapist to help the parents come to a practical solution. I personally think the best way forward is to adopt the principles of collaborative law, which I've been trained in many years ago, and a large number of family lawyers are resolution trained in this country. And what we can do is take a principled approach rather than a positional approach to resolving and reducing confrontation and conflict between parents during the lockdown. At the moment, it's a necessity because of the limited availability of the family court during COVID-19. But I think it's going to be really important going forward because we know that the direction of travel is to try and keep these disputes out of court. And I do sincerely believe that this may prove a lasting and kinder way to achieve better outcomes for the children of separating families. I would say if you're watching this video and you do want assistance in resolving a dispute that you may have with the other parent, please do feel free to give us a call. We are all fully operational during COVID-19 and we will be here for a long time to come also when COVID-19 comes to an end. Please do give us a call or send us an email and we will very quickly respond. Thank you very much for your time today.